Hi, my name is Zak Goldstein. I'm a criminal defense lawyer in Philadelphia. I'm a partner in the law firm Goldstein Mehta LLC. And today I wanted to talk to you about the common defenses in possession with intent to deliver cases. Possession with intent to deliver is a very common charge in drug cases. It involves not just possessing drugs, but having them with the intent to deliver, meaning you weren't just going to use them for personal use, you were going to sell them. And there's really three main defenses in drug cases where they charge possession with intent to deliver. There's a fourth one, which is that they're not real drugs. That defense usually isn't going to fly because they're usually going to test them and know that they are drugs. But there's three main defenses that we would use or be looking for in these types of cases. The first defense is whether or not the prosecution, through their usually police officer witnesses, can prove that the drugs actually belong to the defendant. That's a doctrine called constructive possession. Where drugs are found on a person, then it's likely they are that person's drugs. But when the drugs are not actually on the defendant, if they're in a car, maybe they're in the glove box, maybe they're under the hood, maybe they're in a bag in the back, maybe the drugs are in an alley and there's transactions going on nearby, there might be a defense based on constructive possession that the prosecution cannot prove that they were actually the defendant's drugs as opposed to to a different passenger's or someone else's, or that the defendant ever actually possessed those drugs. Because possession with intent to deliver requires that the prosecution show possession, meaning actual possession that they're on you, or constructive possession, meaning that the defendant had the intent to control the drugs and the knowledge that they existed. So that's the first defense we're always looking for. If we could prove they're not the defendant's drugs, or rather defeat the Commonwealth's evidence that they're the defendant's drugs, then that would be a complete defense in a possession with the intent to deliver case. Now, the second defense we're always looking for in a drug case is a motion to suppress. Under the United States Constitution and the Pennsylvania Constitutions, if the police or other law enforcement agents, they have to be government agents, find drugs on somebody or in somebody's house or car, and they find those drugs as the result of an illegal search or an illegal stop, then it may be possible to have those drugs excluded from evidence and thrown out. And once they're thrown out, the whole case could get dismissed, because now the prosecution can't use the evidence against the defendant. So that's a very, very common thing we're looking for, is particularly in cases where the police don't observe narcotics transactions, or alleged hand-to-hand exchanges. We're looking for, what was the basis for the stop? Was this an anonymous tip, which doesn't give probable cause to stop somebody? Did they actually see the defendant doing something suspicious or doing something that suggested drug activity? Did they need a warrant? Because police conduct all sorts of searches without a warrant. They often need a warrant, especially for a home. And so we're always looking for a motion to suppress as to whether or not those drugs should be excluded because the police violated the constitutional rights of the defendant. Now, the third major defense in a possession with intent to deliver case is whether or not the drugs may have actually been for personal use. If the police find a relatively large quantity, but there's no indicia of sale, there's no transactions, there's no scale, there's no new and unused packaging, then we might be able to use an expert or cross-examine the Commonwealth's expert to show that it's not unreasonable for someone to have possessed that quantity of drugs just for their own use. And so that could be a way to get a case that would normally be very serious and a felony possession with the intent to deliver down to a misdemeanor, simple possession, which is a much less serious charge. So those are the three main defenses that we're looking at in a drug case. And our attorneys have litigated quite a few cases. We've won motions to suppress, we've won cases involving expert witnesses, and we've won cases at trial, and even obtained dismissals at preliminary hearings. So if you're under investigation or facing charges for a drug case or any other criminal offense in Philadelphia or New Jersey, call us at 267-225-2545, and we can talk about how we can help.